Yes, thank you, Mr. Chair. Mr. Attorney, you might remember last November I asked you some questions about the police prosecution of Christo Lanka. Do you remember that?
I do.
And that was in the context of a discussion about the efforts by the police to put in place a suppression order on, if we can use the term, the publication of the coverage of various political commentary about the government in relation to Mr. Barilaro. You remember that?
I do.
And I think it transpired in evidence that the Crown Solicitor had given advice to the police about whether that application had reasonable prospects. And I think the evidence was that it didn't. The Crown Solicitor was a bit hesitant last time. Obviously, we don't want to get into the details of the advice given to a client. But can I ask you, Mr. Attorney, I think in the transcript you said you would inquire into when the advice was given. Can you or the Crown Solicitor tell us approximately the date at which the advice was given to the police service about?
I'll invite Ms Smith to respond.
I'd have to take that on notice.
Okay. Do you think it's possible you could have inquiries made so that during the course of the day we could find out? So I might do some follow-up questions. The issue here was whether or not the police had sought the legal advice prior to making the application or subsequent. And I think it was their evidence that it was subsequent rather than beforehand. I think we agreed, Mr. Attorney, that it's always prudent to get legal advice before embarking on such a matter. I think you'd agree with that?
As a general proposition.
It was as a general proposition, that's right, yes. Now, in relation to that matter, you were also a bit hesitant to make comment because the matter was before the courts. On the 10th of March, the police withdrew the matter and agreed to pay costs. That suggests, doesn't it, that the application was unmeritorious? Would you generally agree with that?
Well, look, apart from media commentary and social media commentary, I've had no involvement in that matter. I've never received, I'll withdraw that. I have my best recollection is that I've never had a brief on the matter. I've never discussed it with any of my colleagues. I've never discussed it with the police. So apart from media reporting, I'm not au fait with the precise details of the matter. I think what you're implicitly doing now is that now that the charges have been withdrawn, inviting me to provide a commentary that I was unwilling to provide last time, I'm still unwilling to provide that commentary. I don't think it's appropriate for me as the First Law Officer to be commenting on matters where I'm not across the detail, and I'm not required to be across the detail.
Sure.
I understand impressions that can be given by withdrawing the charges, and I certainly understand the criticism of the police action in that matter. There is a suggestion that the gentleman who was the subject of that charge might take civil action. I've seen on social media suggestions that the matter may be referred to the Law Enforcement Conduct Commission. At least at the moment, while there's a live prospect of the matter going to the Law Enforcement Conduct Commission, I don't think as a member of the executive I should be giving any commentary that hints at whether the LEC should or shouldn't uphold any complaint that is made. I think that runs the risk of sort of like an improper signal to an independent body that oversights the police.
Sure. But the context of this is we have the defamation action, I think, brought by Mr. Barilaro in the federal court. Yep. Then you have, if you like, the arrest of the producer of the program that gave rise to the defamation action. And I think I was exploring with you, as the First Law Officer, the appearance that, the agents of the state, in the form of the police, appeared to have been deployed against a political critic of the government. Do you understand that criticism?
Look, I understand that criticism, but I don't think it's appropriate for me to endorse that criticism or withdraw or undermine that criticism. It may be different if and when if LEC investigates the matter and makes findings. It might be appropriate then for me to comment, just as I did last year with Operation Monza, where there had been a LEC inquiry and a LEC report, and I was willing then to offer my own disapproval of police conduct leading to that matter. But at the moment, where I think there is a live prospect that it will go to an independent commission to look at, I don't think it's appropriate for me to be giving signals to what that commission should or shouldn't find.
Okay, so you're now the minister responsible for that commission now, aren't you?
That's correct.
And that's new. You weren't the minister in November.
That's correct.
So under Section 34 of that Act, the minister can refer matters to the LEC for their review. Based on what you now know, what's in the public domain, are you sufficiently concerned about this matter to refer it to the LEC to make sure that there's public confidence?
Well, look, I will see whether any private citizen refers the matter to the LEC. I think.
You wouldn't like to get ahead of it yourself?
No, well, I think there is a fair chance that some such referral may happen. As my present view is, if that referral were to happen, then I wouldn't need to take further action. If it doesn't happen in due course, then I'll consider what's appropriate.
What's due course? Like what sort of time frame are we looking at?
We're not talking about years, we're talking about days, somewhere in between, months.
We're not waiting for the government's response to raising the age of criminal responsibility, for example, or some of those other matters. This has got a bit more urgency attached to it.
Well, I will deal with it promptly. I don't know that it's got urgency in the sense that it's something that requires a turnaround of days.
Okay. How much money has the New South Wales government essentially had expended on this matter? You've got this police investigation, the police prosecution withdrawn. The police themselves have voluntarily, as I understand it, agreed to pay the costs in that matter. You've got the use of the court time. Do you have any sort of rough estimate about how many millions of dollars this has cost the taxpayers?
Well, I don't know. I don't. In terms of police resources, you're probably best to ask the police minister that question. I understand his appearance has been postponed.
Yes.
Ms Smith may know the extent to which Crown Solicitor resources have been allocated, and if you want me to, we can go away and work out the number of days and an hourly rate and prorate it. But I couldn't do that on the spot. In terms of court resources.
Yeah, I'd just be interested to know what is the total sort of cost to the taxpayers of New South Wales of that matter, insofar as you're able to.
Yeah. Well, as I haven't participated in any way in the matter, I don't know, and I don't know, for example.
There's no personal criticism of you, Mr. Attorney.
No, but I don't know, for example, now that there's been an order for costs, I think.
They were fixed.
What the quantum of that will be?
$12,000.
Okay.
That was no mystery about that. It was all dealt with very quickly, I understand, in the Magistrates Court. But this whole matter arose because, according to Assistant Commissioner David Hudson, when he gave evidence to estimates, the police didn't follow their own internal processes within the fixated persons unit. Is that a matter that concerns you as the minister responsible for the police watchdog?
As the minister responsible for what?
The police watchdog, the LEC.
Well, look, again, I'll see what private citizens do in the near future, and if they don't, then I'll consider what action I should take in terms of a referral to LEC. Okay,
so you're also, as the Attorney General, responsible for, if I might use the term broadly, the integrity of the legal system. You accept that?
As a broad proposition.
As a broad proposition. Are you concerned about what this matter has to say about the integrity of that process, about how, the police have apparently embarked on this matter without perhaps taking legal advice, without, at least on their own conduct, having a strong case?
Yep.
Withdrawing that matter?
As I mentioned at the outset, Mr. Searle, I haven't been involved in the matter. My best recollection is I've never been briefed about the matter, but obviously I've read commentary in media and I've heard the evidence here last time and your questions last time and Mr. Shoebridge's questions last time. So look, that's something I will look at, but it may be that a private citizen might bring a complaint in the meantime.
Okay. I think we established that as a general proposition, as the Attorney General, you're you're responsible for the integrity of the court system. You accept that as a
Oh,
general
as a broad proposition.
And
It doesn't mean, though, that operationally, where, for example, over 300,000 criminal cases go through the local court every year, that I can be looking at the integrity of each and every matter. Obviously, there's a degree of delegation and broad oversight.
Yeah. But obviously, where matters come to your attention, if they're sufficiently serious, you might take an interest.
Depending on the circumstances, yes.
Yeah. Now, one of those aspects of integrity is about the giving of evidence in court. It's a criminal offence, isn't it, to interfere with a witness or to try and procure certain evidence, or to essentially
Well, broadly speaking, yes.
to coach
That's
witnesses.
correct. That's correct.
And that's 323 of the Crimes Act, I think. In relation to, and you're also as the attorney, although they're an independent body, you're also the minister responsible for the DPP, aren't you?
That's correct.
Are you aware of another matter involving the Police Fixated Persons Unit, a prosecution brought by the DPP on the advice of the police, I think? That was broadcast last night involving Police Fixated Persons Unit?
Oh, look, I've seen briefly in my skimming of media clippings this morning, there's something that I've seen a reference to a matter.
Yeah. We've got some video here I might play for you. Is that okay with you?
If you'd like me to watch it?
Okay, if we might just play the video with the sound down. I don't think it's required. It should come up on the screen, Mr. Attorney.
Thank you.
Now, this is all in the public domain. Yep. So this is proceeding inside a courtroom. It's from the court CCTV. Down the bottom, you can see the police officer making signals to the witness, catching the witness's eye. This is a second witness, also catching the officer's eye, causing the lawyer to turn around. Obviously, there's some things going on in the courtroom here. Subsequently, we've got the officer talking to people who haven't yet given evidence. He seems to be doing all of or most of the talking. That's the same footage. So
Can I just interpose,
course you can.
Mr.
Pause,
Mr. Searle? I'm not sure whether it is a contravention of the Court Security Act for you to be playing this from CCTV. I'm not saying it is or isn't.
I don't
but
think it is.
Me sitting here and nodding my head is not acquiescence
No, I understand
in any legal contravention
No,
that may or may not be taking place.
My understanding is this is covered by parliamentary privileges as a proceeding.
Covered by
Parliament.
parliamentary privilege.
Okay.
Yeah, we have seen the police charge in and arrest people with no notice, though, in those circumstances.
Anyway, Mr.
Threatening that, are you, the
Mr.
attorney?
Shivridge, I'm asking the questions. So here you can see a police officer sending a text message. We don't know to whom or about what. Keep playing, please. And then someone who's a witness outside diving into their bag. Obviously, looks like they might have heard their mobile phone go off. And this is the witness, the key witness giving evidence. And that's subsequently the police officer subsequently talking to people who have yet to give evidence. So something's going on in the courtroom, and then the officer subsequently goes and talks to people. Anyway, I think that's essentially you get the sense of it, Mr. Attorney. Now, I believe that's the same officer that was involved in the arrest of Christo Lenker. Now, that was a matter that seems ill-conceived, and the police have withdrawn that. This was a matter also brought by the Fixated Persons Unit. There was a conviction in that matter, but it was subsequently overturned by the District Court on the basis of insufficiency of police investigation, not on any other basis. But there does seem to have been, at least in passing, if you read the judgment at paragraph 14, a query over the credit of the evidence, if I can put it neutrally like that. Having seen that, as the Minister responsible for the prosecution service that brought that prosecution on the advice of the police, and seeing the involvement of that same officer involved in the other matter we were discussing, are you now sufficiently concerned about the possible interference with the integrity of that proceeding to refer this to the Law Enforcement Conduct Commission, or do you need to consider that?
I'd need to consider that further.
Okay. But it's something you will consider now?
Well, now that you've raised it, I will consider that.
Okay.
It's not clear from that video. Well, obviously,
No, it's not.
we haven't got any sound, so I
No.
don't know what the officer was saying to the person outside.
Agreed.
And the witness, I think you're suggesting that at the same time as he's texting something, she is looking at her phone.
It looks that way.
Yeah.
It looks like he sends a text to someone, she hears something go off in her bag, possibly her mobile phone message being received. But it does look, when you review the material, at least it looks to me, like there is coaching of evidence, including catching the eye of two witnesses in the witness box.
Well, look, obviously, it is grossly improper to coach a witness. I, to be honest, can't tell from that video that that's happened, but I'll give that further consideration.
Okay, but now that you're aware of it, it is something that potentially concerns you as the Minister responsible for
Well, it's something that I'll give further consideration to.
Okay, but you'd agree that it's important for the public to be able to have confidence in the integrity of evidence given in particularly criminal prosecutions, but all court proceedings?
Absolutely. It's critical that there is confidence in the integrity of the criminal justice process, and that includes the witnesses telling the truth without interference.
Yeah, and there's a reason why witnesses, particularly in criminal matters, wait outside the courtroom while earlier witnesses give evidence, isn't there? That's
right. So typically a witness won't go into court until they've given their evidence, so that their evidence isn't coloured by watching what other witnesses are saying or doing in court.
Yeah, and it would be an interference with that general proposition if somebody were to be briefing witnesses about what had happened in court.
Well, that's right. I mean, it's not improper, for example, for someone to tell a witness. In fact, it's what you should do. Tell a witness that you will go in the witness box. You'll be sworn in. Your counsel might ask you a few questions, and then counsel on the other side will cross-examine you. It's not improper to find out what the witness is likely to say. Get their witness statement.
Proof of evidence. For example.
Proof of evidence, as you'd know, but. Obviously, it's improper for witnesses to be colluding or for coaching to be taking place.
Yeah, and where that happens, if that's if it's the case that that's happened, that's a concern, and if it's the case that involves the police in this particular instance, if that was to be the case, that would also be a matter of concern.
Yeah, if hypothetically there were that coaching, then it's a concern, and if hypothetically it's coaching by the police, well, then that would make it worse.
And that would be a matter, if you were satisfied of that. That is a matter you would refer to the LEC, or would you wait for a member of the public to make that concern?
I'd see whether a member of the public were doing it, but I wouldn't be waiting for a long time.
Now that you're aware of this matter, is it something that you will evaluate expeditiously?
It's something I will evaluate. Well, I will get advice on promptly.
Okay, thank you very much. I think those are my questions.
For the moment.
Yep.
Nice to see you, Attorney. And
Likewise,
again,
thank you.
This is the budget estimates hearing that will not end. I think this is the third round. So welcome back.
Thank you.
Attorney, going back to the Kristen Lenker matter, we know that the state of New South Wales, through the police, has had to pay at least $12,000 in costs to Mr. Lenker for the legal expenses that he's incurred. We know that it was an appalling allegation to make against somebody that they engaged in the crime of stalking when there was never sufficient evidence for the police to proceed with that. Are you saying that after an incident like that, where the charges have been withdrawn, a substantial amount of public money is paid over to the defendant for a case that should never have been brought, that there's no systemic review of it.
No.
Your department does no systemic review. Is that what you're saying?
Well, I don't as Attorney General. I was asked a question by Mr. Searle about the integrity of the legal system. Given there are hundreds of thousands of cases that come to court every year, I in my office don't have the resources to be looking at every case that has come to court. If charges have been withdrawn,
hang on, we're not talking about every case.
I haven't finished my answer. If charges have been withdrawn, then you would think that means that police don't think they can prove their case. Whether or not the case should have ever been brought in those circumstances is not something that I, as an outsider at the moment, can opine on. And I'd expect that if a private citizen has a complaint about that, they will take it to LEC, and if they don't, then I'll consider what I may do.
Well, LEC has no oversight of the courts. That's not LEC's job.
Well,
LEC has no oversight of proceedings in courts. That's your job, Attorney.
Well, the implication here is that, well, I would just be clear, the suggestion you might be making is that the police have acted improperly in this matter. That is not any reflection on the court. That's a question of police action. I anticipate the fair chance that a private citizen will make some sort of complaint about that to LEC. So at the moment, I will wait and see what happens in that respect. But it's not a court oversight matter. It's a police oversight matter. Because no evidence was ultimately led in the court, and the court was not required to make a determination.
No, but it was on the initiative of the court that, admittedly, commenced by the police, but it was the court that effectively initiated it was the court proceedings and the power of the court that compelled Mr. Lanker to be there and to incur the legal costs. I don't understand why there isn't a process in the Attorney General's Department to at least do a basic review when the courts on the face of it have been abused like this by another government agency. Because if we're just relying on police investigating police, nothing will happen.
Well, look, if there's been an abusive process by the police, you've got an independent law enforcement conduct commission there to oversee that. You've also got independent courts that, if the matter goes far enough, can make findings about an abusive process. A litigant can contend in court that something is an abusive process. So when you have courts potentially dealing with that issue, when you have an independent police oversight body dealing with that issue, you don't need a politician and his staffers, or indeed his department, overseeing that as well. You've got two independent oversight mechanisms already. The courts, if a matter progresses far enough, on the one hand, and the Law Enforcement Conduct Commission on the other hand.
So in this case, it was simply a matter of accidental good fortune that Mr. Lanker managed to have sufficient resources to fully test the police case and challenge it in court. Now, he just may have enough resources to bring another civil case at yet more expense to try and vindicate his rights. But are you saying for those people who don't have those resources and they're not able to bring a civil case, that there's just nothing?
No.
Your department won't do anything because you're saying it's up to them to challenge an organisation as powerful as the New South Wales Police?
No, I'm just saying there is a taxpayer-funded Law Enforcement Conduct Commission that is independent of government, that can receive complaints from the members of the public without any need for vetting or imprimatur from the executive. So there is a mechanism there. I take your point about civil proceedings and that, unfortunately, typically you need deep pockets to bring civil proceedings. I take that point. But so far as police oversight is concerned by the Law Enforcement Conduct Commission, you don't need a deep pocket to make that complaint.
You know that the Law Enforcement Conduct Commission investigates a fraction of the complaints. It's, I think, 2 or 3% of the complaints it receives because it simply doesn't have funding to investigate more than 2 or 3% of the complaints. You know that, don't you, Attorney?
Well, I don't know that. It may well be.
Well, you're the minister responsible.
Hang on, I haven't finished my answer. I don't know that. It may be that only a minority of complaints are investigated, but LEC would also have a vetting mechanism where if they don't think a complaint is sufficiently serious or well-grounded, they won't pursue it. But if a complaint is made in this case, then well, I don't want to hint at what LEC might do, but there's no reason to think LEC won't look at it.
Well, you challenged my proposition that it's only a tiny fraction of the cases that are referred, the complaints that are referred to LEC that are investigated. If it's not 2 or 3%, let me finish. If it's not 2 or 3%, what percentage of complaints end up being fully investigated by the LEC?
I'll have to take the percentage on notice. I didn't challenge your proposition that only a small percentage end up being fully investigated. What I did challenge was the suggestion that it is a resourcing issue, as distinct from filtering by LEC to work out what cases it considers are worthy of investigation and what cases are either well-grounded or not sufficiently serious that warrant its attention.
Well, the LEC has made it clear in its annual reports that it has insufficient funds to do the tasks which it's been assigned. It said that in its own annual reports. You're not challenging that conclusion from the LEC, are you? Well,
the LEC and other integrity agencies at the moment have been consulted by government about what their baseline funding should be going forward. As you know, there have been parliamentary inquiries and an Auditor General's report about funding of integrity agencies, and that's something the government is looking at in the next budget.
Attorney, you've just seen a small part of the video evidence from the more recent trial, which were the actions of an officer who was one of the primary movers in the Christo Lanka prosecution. Again, is engaging in actions which, on the face of it, appears to be highly problematic. You don't think that those facts together should motivate you to commence some investigation of what's going on in the courts?
Well, I'll give that consideration. It wasn't entirely clear to me watching that video just exactly what happened. The fact that a policeman is speaking to witnesses outside court, unless you know what he's saying, what they're saying back and what it's about, you can't necessarily jump to conclusions. The fact that someone in the witness box picks up their phone, I can't. I don't think that
wasn't in the witness box. That wasn't in the witness box.
Well, I can't sitting here jump to conclusions and join the dots. Now, I want to be very clear that if there is any coaching, I'm not excusing that, and I'm not saying it did or didn't happen. I just can't tell from that video what happened. And as I said, I'll give the matter further consideration. But on the basis of a video without sound, sitting here, I'm not going to jump to conclusions right now.
Well, Attorney, I'm not asking you to form a conclusion, but I am going to ask you whether or not you'd be willing to look at the very lengthy video, which you only saw a small fraction of, where the officer repeatedly comes out of the court and repeatedly speaks to witnesses waiting as the evidence is unfolding in court. Now, will you seek a review within your department of the evidence that shows that repeated behaviour by the officer?
I will get advice from the department.
And can I indicate the behaviour is particularly troubling because the officer appears to be repeating hand movements indicating critical elements of the case as given by witnesses and as conveyed by counsel in the course of the proceedings. That I accept, as you say, we can't draw conclusions from what's there, but I would suggest to you, and I'd ask if you agree, there is sufficient there to commence an investigation.
Well, look, I can't agree or disagree. There is insufficient there to form a conclusion, but you're not putting that to me. You're saying, will I investigate? I will get advice.
Right. Last time we spoke, Minister, about another example of what was unquestionably gross police behaviour involving court proceedings, which were the conclusions in Operation Monza, where the police intentionally and deliberately harassed a solicitor on the way to court, which was the finding of the Law Enforcement Conduct Commission, you said you were seeking advice from the police themselves about whether or not they would take any action. Well, it's now the better part of 12 months since that report was delivered. What advice have you received from police?
So I think I reported last time that I'd asked the then Police Commissioner what, if any, action he proposed to take. He wrote back to me to say that he wasn't taking any reviewable action, I think it's called. LEC had recommended that the Police Commissioner look at doing that. Reviewable action, I think, is action that can be reviewed by the Industrial Relations Commission. The Police Commissioner, and I'm paraphrasing loosely, told me in writing that he wasn't going to do that. He had, I think they had been admonished or some such thing. The view I take is that it is fundamental that any participant in the legal system not be the subject of harassment for doing their job, and that extends not just to judicial officers, it also extends to lawyers. Defence lawyers play a vital role in our criminal justice system in terms of fair representation. It is not good enough that if police have a gripe against the clients, that they implement that gripe by harassing lawyers. Might I say that Strikeforce Raptor and the police generally do a fantastic job, but on this occasion they let themselves down. I think it's important that our legal processes stand up for defence lawyers and the integrity of the legal system in this respect. So that's why I am consulting on extending other provisions of the Crimes Act that Mr Searle didn't mention earlier to cover defence lawyers. The protection that is given against interference to judicial officers, for example, extends to defence lawyers.
So a senior officer in Strikeforce Raptor plans an operation with other police officers at public expense to camp outside a solicitor's office on his way to court to defend a matter brought by Strikeforce Raptor. They intentionally and deliberately harass him repeatedly on the morning before going to court. They engage in intimidatory action outside his office on his way to court. He's so fearful of his position that he tells the magistrate he can't proceed on the day because he's frightened by what happens to him. And the outcome from the legal system is the police commissioner has determined to admonish those officers. No charges, no fines, no serious action. They get an admonishment. That's the outcome, is it?
Well, that has been the outcome, and in my view, given the recommendations of LEC that have not been implemented, I'm now looking at reform to the Crimes Act so that someone in those circumstances has the protection of the criminal law.
That seems a sensible step forward, and I'd urge you to bring that legislation forward as soon as possible. But interference in the administration of justice is a criminal offence. Contempt of court is a serious criminal matter. Why have neither of those options been considered by you and your department, given the police in this case intentionally planned to intimidate a solicitor on his way to court in a case against themselves?
Yeah. I don't know what consideration has been given to criminal charges. I did get a brief about the matter and whether it would rise to the level of the section of the Crimes Act that Mr Searle referred to,
323.
Perverting the course of justice. I don't want to weigh privilege over that advice.
No, I'm not asking you to.
But having received that advice, I don't think it would be a productive use of resources to prosecute. In the event, of course, I'm not a prosecuting authority. I don't have the resources to prosecute. The DPP also, while they're a prosecuting authority, they have to rely upon a brief from police. But having taken some preliminary advice on the matter, I don't think a prosecution here would have sufficient prospects of success to be worth bringing.
Well, Attorney, a key reason for that is the police have refused to investigate it. They haven't even commenced disciplinary action, let alone referred the matter off for a criminal investigation. We often talk about the failures of police investigating police. This is even worse. This is police refusing to investigate police, and you're saying because there's no evidence there, despite gross and obvious malfeasance by the police, if they refuse to gather evidence about themselves, it's a dead letter. Nothing can happen.
I didn't say that. I said the police elected, or the Commissioner elected, not to take disciplinary action of a reviewable kind, for example, a dismissal or a demotion or a suspension, but some kind of admonishment or something like that. I don't know what consideration police have given to bringing charges. I mean, it's a fair inference. No, I'll draw that. I don't know what, but I in a brief had some preliminary advice that I don't want to waive privilege over, but having seen that advice, I don't think a prosecution would be successful.
But that advice was in the absence of any brief of evidence or of any investigation, because as you point out, Attorney, it's not your department's job to investigate. In this case, it's the police's job to investigate. Well, so what happens here? Is there just a big justice hole that these matters fall into?
No, I don't think so. There's an internal affairs unit, an internal disciplinary unit in the police. In terms of fact-finding...
But that's subject to the direction of the Commissioner.
Hang on, but in terms of fact-finding, the advice that I received was based on the facts as found by the Law Enforcement Conduct Commission. So that advice didn't require a lot of further fact-finding. There had been findings of fact by LEC on which that advice was based and on which LEC's recommendation to the Commissioner was based. So even if the police had not investigated the matter, LEC had investigated the matter, and LEC did not recommend, having found those facts, LEC did not recommend the bringing of criminal charges. It recommended disciplinary action, but it did not recommend the bringing of criminal charges. And what I've said in these circumstances, where having taken advice, it didn't seem that a prosecution was successful, and no disciplinary action being taken here. I'm not seeking to retrospectively bring criminal proceedings here, but I want to consult on filling what appears to be a gap in the law, bearing in mind it may not just be as simple as inserting defence lawyer or lawyer into a definition of whatever it is, legal officer, because it may be in some circumstances that a retribution against a lawyer should not be criminalised. For example, if a client is unhappy that his or her lawyer is representing somebody else, they may say, well, I'm sacking you as my lawyer because of action that someone has taken in a proceeding. So there may be circumstances where you don't want to criminalise across the board threats or retribution by someone against a lawyer. But in a case like this, a defence lawyer who is doing their job shouldn't be harassed or intimidated, notwithstanding what the police think of their client. And as I said before, the overwhelming majority of the cases, police do a fantastic job, but on this occasion, they let themselves down, and the community.
Attorney, will you table the written response you got from the Police Commissioner?
Yes, certainly. I don't have it here, but I'll certainly
make it available. If you can table it at some point today, that would be appreciated. Did you seek advice on whether or not the actions of the senior officer and other officers from Strike Force Raptor was potentially a contempt of court and actionable as contempt of court?
I don't believe so. My best recollection is I didn't.
Can you provide any further detail about that on notice?
Certainly.